I think everybody is on, and I thank everybody for coming. This has been a subject, as everyone knows, that has been the only thing in the news for the past month or so. So I know there's information coming from everywhere about how to prepare, and we really appreciate you coming and joining this webinar. My name is Colin Thakkar, and I am special counsel at Jimerson Birr, specializing in management side labor and employment law. My colleague, Brandon Meadows, is a special guest on the webinar, and he's going to be speaking more on the financial side. Brandon, would you like to introduce yourself?
Sure. Thank you all for joining. Brandon Meadows here. I'm a partner with the law firm, and I'm a member of our banking and financial services industry team. And we have been closely following all things COVID-19 and all of the implications that it has on our clients. And I have specifically been focusing on the CARES Act and the relief that's been afforded there, and advising our clients of what relief is available. And I'll be touching base on that when that time comes. So thank you for having me.
All right, thanks, Brandon. So as I kind of foreshadowed to earlier, this has been a very difficult time for all of us over the past couple months. Ever since the coronavirus has come into the public consciousness, it's been in the news, and it started out obviously with all of us concerned for ourselves, for our families, other concerns in our personal capacity, and then at the same time really transitioned to concerns of a professional nature. And it did not take long before businesses were having significant difficulties keeping customers, keeping supply chains going, and on. This resulted in many employees not being able to work or losing their jobs, and businesses being at significant risk of closing down and going under. As a result, the federal government has taken some very big steps, and in many cases very good steps, very much needed steps to prop up businesses, and also prop up workers and incentivize businesses to keep their workforce going through this downturn. And I am here, and Brandon's here, to talk about the two most significant pieces of legislation that relate to the workforce. Number one, the Families First Coronavirus Response Act, which I'll refer to from time to time as FFCRA. And number two, the Coronavirus Aid, Relief, and Economic Security Act. The FFCRA was geared more towards providing benefits for employees who are at risk of being laid off, or at risk of losing wages due to either the coronavirus itself, getting diagnosed with the virus, or being subjected to stay-at-home orders. And the FFCRA was focused on providing leave, specifically paid and protected leave. Number two, the CARES Act, that was mainly that was designed more to provide economic stimulus to businesses to keep them going, while also putting in hooks to incentivize them to maintain their workforce in order to get the maximum stimulus available. So first, I'll speak about the Families First Coronavirus Response Act. The FFCRA was signed on March 18, 2020, and although it wasn't immediately clear when it was when the effective date would be, the government subsequently confirmed that the effective date was April 1st, and it applies to leave taken between April 1st, 2020 and December 1st, 2020. Now, the FFCRA has two primary workforce provisions. Number one is the Emergency Paid Sick Leave Act, and I might refer to that as the Paid Sick Leave Act or the PSLA, as well as the Emergency Family and Medical Leave Expansion Act, which is a mouthful, and the FMLEA is also a mouthful, so I'll try and do a good job saying those through the webinar. Now I'm going to tell you talk about what the Paid Sick Leave Act and FMLEA do. First, the terms of leave. The PSLA provides up to 80 hours of paid leave at a full-time employee's regular rate of pay. If the full-time employee is instructed to stay home, either by a government order or a physician's instructions, or if the full-time employee is experiencing COVID-19 symptoms and seeking a medical diagnosis. Now, some people have asked, so a person can get leave if they're experiencing symptoms and seeking a diagnosis. What happens if they get the diagnosis and it's positive? Then do they still get paid sick leave? And the answer, the DOL clarified that yes, that would fall under, it should fall under a person being instructed to stay home on a physician's instructions. I think it's pretty universal that a physician would instruct somebody with coronavirus to stay home, and so for that reason, they would also be eligible for paid sick leave up to 80 hours. Now, I said for full-time employees, which is true, and for part-time employees, they wouldn't get 80 hours of sick leave because the sick leave is supposed to provide leave, paid leave for 2 weeks. And so if you have part-time employees, then the number of hours that they would get in or be eligible for in paid sick leave would be the average number of hours that they work over a 2-week period. Next, the PSLA also provides up to 80 hours of paid sick leave, in this case at 2/3 the regular rate of pay. If the employee needs to care for an individual, for another individual who's subjected to a quarantine order, or needs to care for a child whose school or daycare is closed or unavailable in the case of daycare, or an employee who's experiencing a substantially similar condition as to coronavirus as specified by the Secretary of Health and Human Services. The Secretary hasn't designated any other substantially similar conditions as warranting paid sick leave, so that's an issue that we can leave for the future. Now, for both of these, those are the different types of leave that qualify for paid sick leave under the Paid Sick Leave Act. Even though they are given leave, the employees are given leave at either the regular rate of pay or at 2/3 the regular rate of pay, that cannot go above the caps, which are for full-time employees, or for the first category where employees are paid their regular rate of pay. The amount of paid leave per day is capped at $511 per day. And then for the second category where employees are paid 2/3 their regular rate of pay, it's capped at $200 per day. All right, next, under the FMLEA, that provides up to an additional 10 weeks of paid leave. And so it's 12 weeks in all under the FMLEA, but the first 2 weeks are unpaid. So it provides 2 weeks of unpaid leave and then an additional 10 weeks of paid leave at 2/3 the regular rate of pay, again capped at $200 per day. If the employee needs to care for a child whose school or daycare is closed or unavailable. And you'll notice that that same category of leave is a reason for leave under the Paid Sick Leave Act. So If an employee needs to stay home because a child is home from school, then they would get 2 weeks leave under the Paid Sick Leave Act, and then 10 subsequent weeks leave under the FMLEA. And as I said before, the dates of coverage for these acts are April 1st through December 31st of 2020. All right, now I'll get to the small business exemption. Many of you have may have seen that the Department of Labor just issued new regulations, and these were emergency regulations, so there wasn't a period of time for notice and comment. They drafted them as quickly as they could and issued them, and they are currently in effect. One of the things that they stated in or included in the regulations was this small business exemption, where which applies only to the employees who need to take leave either under the Paid Sick Leave Act or the FMLEA for the reason that they need to stay home to care for a child whose school or daycare has closed or become unavailable. So the Department of Labor in that situation will exempt small businesses defined as businesses with fewer than 50 employees from their PSLA and FMLEA obligations, provided the reason for leave is to care for the child and the employer is able to establish one of the following conditions, which all of which have to do with the employer basically not being able to carry on their business if they're forced to grant this paid leave. Number one is financial hardship, that the employer just doesn't have the money to be able to spend on paid leave for that reason. Or the key employee provision, which is that the employee requesting leave carries on the type of specialized duties and responsibilities where he or she cannot be replaced by anybody either inside or outside of the workforce on short notice, or simply a lack of manpower. And that can involve key employees, not really key employees, so they don't have to have any specialized duties, but just you don't have enough, your workforce isn't big enough to be able to shoulder the weight of carrying on in the business without this employee or without these employees at work. Next, we're going to talk about tax credits, and this is how the government has struck a balance between paying employees who are in desperate situations and need the money on the one hand, and not making it financially ruinous for businesses. So in exchange for a business providing paid leave under the Paid Sick Leave Act or FMLEA, the employers are able to get a tax credit, which is equal to the full amount of the qualified PSLA or FMLEA wages that are paid, in addition to qualified health plan expenses and the employer's share of Medicare taxes that are paid during that period of leave. The employers can deduct the full amount of this tax credit from federal employment taxes that they've withheld. So the employers don't have to wait for the government to give them the money that they already spent on sick leave. They can simply deduct that money from taxes that they've withheld instead of submitting those taxes to the IRS. Second, if the tax credit amount exceeds the employment taxes that have been withheld, the employer can apply to the IRS for a refund of the balance. Next is something, I don't know how many employers were really asking, can we pay sick leave greater than the capped amounts? But it was something that the Department of Labor saw fit to clarify. So when they say that the paid sick leave is capped at $511 per day or $200 per day, they're not saying that you can't pay more to your employees who are on leave. They're just saying that they won't reimburse you for the balance. So if you pay, if you pay $600 a week instead of $511 a week, you're going to be on the hook for the $89. So that's just something to keep in mind. It's up to you how much you want to pay your employees while they're on leave. Next, we get to prohibitions. In addition to requiring that employers pay employees or qualified employees who need leave in relation to the coronavirus, the FFCRA also prohibits discrimination and retaliation in really the same manner that you see with Title VII, with the ADA, the Age Discrimination in Employment Act, all of the federal non-discrimination laws, as well as state laws. So what the FFCRA does is it states that employers are prohibited from taking adverse employment action against an employee because that employee has taken leave or really requested to take leave under the PSLA or FMLEA. Second, employers are prohibited from retaliating against an employee for filing a complaint or for initiating a proceeding against the employer in connection with the FFCRA. All right. Next, we get to penalties. So this is interesting. I have an aside when I get to the end of this, based on the new Department of Labor regulations that have just been issued. But specific, the plain language of the Act states that violations of the Paid Sick Leave Act are subject to penalties and enforcement measures set forth under the Fair Labor Standards Act, and violations of the FMLEA are subject to penalties and enforcement measures set forth under the Family and Medical Leave Act. I'll just add right now that with the FMLEA, one of the interesting things about that was that employees are eligible for the FMLEA leave even if their employer has less than 50 employees, which is the standard for the original Family and Medical Leave Act. So if you have less than 50 employees, you're not subject to the original FMLA. With the FMLEA, there isn't that requirement. It can be any company with less than 50 employees. However, the Department of Labor just issued their regulations and clarified that if for employees whose employers have less than 50 employees, they cannot file. They do not have a private right of action to file suit for a violation of the FMLEA. So an employee who has been denied leave under the FMLEA, who has been possibly discriminated against or retaliated against for complaining about a violation of the FMLEA, they cannot go and file a private right of action unless their employer is already subject to the original FMLA. So that's something to keep in mind, and was not. I don't believe it was something that was expected prior to the issuance of the regulations. Another thing that the Department of Labor did after the, in issuing their guidance, their follow-up guidance subsequent to the passage of the FFCRA, was to issue temporary guidance stating that they would allow a 30-day grace period during which they would not enforce violations of either the Paid Sick Leave Act or the FMLEA, as long as the employer acted reasonably and in good faith. And what good faith means is that the employer did not intend to violate the law, that the employer, when notified that they had violated the law, that they corrected it, and they made the affected employee or employees whole, and that they certified to the Department of Labor that they would not violate the law in the future. So there's a bit of confusion on whether that grace period takes place during the entirety of April 2020, or whether it's the 30 days after the act was signed into law. The guidance from the Department of Labor states that it applies to the first 30 days after the law takes effect, which would be all of April, but then it includes the dates that follow from March 18, when the act was signed. So it's unclear whether March or April 17 through 31st or 30th is included in that grace period. So just walk carefully. All right. Another thing that the Department of Labor clarified has to do with the issue where somebody has a qualifying reason for leave. Say they're subject to a government quarantine order, and yet the employer either is closing during that period of time, maybe because the employer is also subject to the government order, or because the employer is closing for lack of work, or because the employer is laying off the category of employees that includes the one seeking leave because of a lack of business. And what the Department of Labor said was that if the employee would not be going to work or working from home, even if the employee was able to do so, then the employee is not entitled to leave. So if an employee has a qualifying reason for leave, and yet that employee would not be performing any work for the employer during the leave time, then there's no need to pay them for that time off. All right. Another question that a lot of employers have is, are we allowed to request documentation from an employee? Say an employee needs to or tells you that their doctor has instructed them to go on leave, to self-quarantine due to either having the virus or having symptoms that make it likely that they have the virus, or because they have because they're immunosuppressed and they're at heightened risk of getting the virus. Are you allowed to request documentation? Are you allowed to request information about that? And the Department of Labor has clarified that yes, you are, and to a certain extent you're required to, because you're applying for a tax credit, and you need to, and also you might be, well, it has less to do with the loans, but you're applying for a tax credit, and you need to be able to show that the application is legitimate. So what the Department of Labor has said is that employers must preserve the employee name, qualifying reason for leave, as well as a statement from the employee. And I would recommend that it be written. It doesn't have to be, but that's just the best practice. A written statement from the employee confirming their inability to work or telework, and identifying the anticipated leave dates. In addition to that, the Department of Labor has authorized employers to request or require additional information, including with respect to leave taken because of a quarantine or isolation order, a copy of that order. In the case of a doctor instructing the employee to stay home, written documentation from the healthcare provider confirming the nature and details of the isolation instructions. And that's not information about their health condition. It's just a confirmation that the employee has been instructed to take leave, and likely some guidance about the anticipated time that the employee will need to be off. And next, in the case of a school closing or a daycare provider closing or becoming unavailable, just some kind of written notice, whether it's a picture of a notice on the schoolhouse door or it's an email from the school just notifying parents that the school is closing, something like that would be fine to request. All right, and that gets us to the CARES Act. The CARES Act is as I said before, the Coronavirus Aid, Relief, and Economic Security Act, signed on March 27th, 2020, that is in effect as well. Brandon Meadows is going to start us off by talking about the Paycheck Protection Program, including some financial details that we think you'll find valuable.
Thanks, Colin. As Colin just mentioned, I'm sure that you all have heard. Can you go back just one slide, Colin?
Sure.
The CARES Act was enacted on March 27th. It was a $2 million stimulus package that had many key.
I'm sorry.
That's okay. You can stay there. You can stay there. Many key provisions to assist businesses and borrowers with immediate loan modifications for existing debt, and then thank you, and then also to provide for additional financial assistance through more lending facilities. And one of the problems that Congress was trying to tackle is, at the back end of this crisis, how do we rebound? And it's going to be difficult if people are out of work. So how do we protect the employees from mass job losses that are imminent? So part of the CARES Act contained a $350 billion set aside for what was called the Paycheck Protection Program, we call PPP. And it's very fluid in that over the last week or so since the enaction of the CARES Act, there's been quite a bit of implementation and guidelines set forth, particularly by the SBA, on how we're going to get the money from the federal government through the SBA approved lenders to employers and eventually to employees. The program effectively provides 100 cash flow assistance to employers vis-a-vis 100% federally backed guaranteed loans to those employers who are maintaining payroll during this emergency. So if those employers are using the monies during the periods that we'll discuss in just a moment, those loans can be forgiven. So that's really the big key to a lot of these SBA loans under the PPP. If your workers are still employed, those loans can be forgiven. It was just rolled out last week, the program, and from what I understand is as of yesterday, there were over 250,000 applications that were processed, and $70 billion total of loans are in the process of being funded. That's 20% of the entire allocation under the PPP. And I heard on the radio this morning that the White House was suggesting moving forward another $250 billion to be pumped into this program. So it's highly desired, and it appears that whether it's working, we don't know, but there's certainly a lot of processing, and a lot of the money is starting to roll out under this program. Big takeaways is who's eligible, right? So small businesses, less than 500 employees. There are a few exceptions, some of them being for franchisees. In the restaurant and hospitality industry, they measure the number of employees on a per site basis. How much can you borrow? The amount of the loan that can be borrowed is based upon a calculation of 2.5 times your average monthly payroll costs, but no greater than $10 million. And the list of what's covered under payroll costs are things like salaries, wages, commissions, cash tips, if those were paid to employees, vacation, parental, family, and sick leave. One point on that would be if there was credits given under the Families First Act, there would be no double dipping there, so that would be exempted. Insurance, other payroll costs include insurance premiums, retirement benefits, etc. The primary purpose and the use of the proceeds is designed for payroll costs, number one, to keep the number of employees on payroll, keep the wages at or near what they were prior to the crisis. Other costs that can be included or the use of funds are for interest on mortgage obligations, for rents, and for utilities. Can you go to the next slide, please? Now, the big key is the loan forgiveness. The amount that's eligible for loan forgiveness equals the amount that's spent on those payroll costs, plus the mortgage interest, plus the utilities, and plus the rents. The big key, though, is those monies are the monies that are spent during an 8-week period from the date of the loan origination and 8 weeks out from that. The forgiveness can be reduced, so that's a key that you need to monitor. If you are reducing the number of employees or you're decreasing the wages beyond 25% of the prior year's wages. And that's consistent with the spirit of what the program is, really, is to help the businesses stay afloat, but really to get money to their employees to keep them on staff and keep them working. No more than 25% can be used for non-payroll costs. And so there are formulas on the back end, at the end of that 8 weeks from the date of origination, when you apply for loan forgiveness, there are calculations that can be used to make sure that those the most amount can be forgiven. And so what's the key takeaway? You need to keep accurate records. I'm sure most of you are. Accurate records of your expenses and expenditures, such information as documenting verification of the number of employees you have on staff, their payroll, their pay rates, including prior year taxes, documentation verifying your payment of your mortgage interest obligations, your rents, and your utilities. You're going to need all that information at the end of the 8-week period when you apply for the loan forgiveness. The loan terms do occur after the 8-week period, and the percentage of the loan that's not forgiven is actually going to be rolled into a term loan. And initially we were hearing that it was going to be a loan for term up to 10 years, no more than 4% interest. On April 2nd, the SBA put out an interim final set of rules, SBA interim final rule on the 2nd of April, stating that the term was going to be 2 years for the loan, interest rate at 1%, principal and interest payments with some interest deferment for up to 6 months. So again, key takeaway is to understand how the calculation of payroll costs are made and documenting your expenditures, so that way if you do end up applying for and taking the loan, that you can take advantage of the forgiveness aspect. And one last piece, although I'm not providing, I'm not a tax lawyer, but from what I understand and from what I've read is that the forgiveness of debt is not going to be counted as a gross income for purposes of income taxes. If there's anything you want to add from an employment aspect, Colin, I'll pass it back off to you.
All right, thanks, Brandon. I think that covers everything. So I will move on to the employee retention credit, and we're just going to discuss a few more aspects of the CARES Act. So the employee retention credit is another benefit that that companies can get under the Act. Unfortunately, only in the circumstance of economic hardship. So companies are eligible for a payroll tax credit equal to 50% of qualified wages paid to employees from March 13, 2020 through December 31st of this year, if either the company's operations are fully or partially shut down due to a government shutdown order, or the company's gross receipts during a calendar quarter are less than 50% of the gross receipts from the same quarter for 2019. The big thing with the employee retention credit is that the definition of qualified wages differs depending on the size of the company. So if the company has more than 100 employees, then qualified wages is limited to only those wages paid to employees who are not working during the time period that they're paid for the wages. So if an employee is staying home because of a government shutdown and continues getting paid wages, then those will be qualified wages. But if there's a partial shutdown and only some of the company's employees have to stay home and not work, then that company will only get the retention credit for the wages paid to the employees who are not doing work. They won't get the credit to the employees who are still working. On the other hand, for a company with 100 employees or less, they'll get the employee retention credit for all wages paid to all employees during that time period, whether or not the employees were performing work during the time that they were paid. All right, and one big thing to remember is that the employee retention credit is not available to companies that receive a loan under the Paycheck Protection Program. Next is a provision allowing for delayed payment of Social Security taxes, and this was a big provision pushed by the construction industry, among others, I'm sure, just to provide relief for businesses' cash flow during the crisis. Pursuant to this provision, all employers, are permitted to delay payment of their 2020 employer Social Security taxes, regardless of whether or to what extent those companies were impacted by the coronavirus. So this is a delay, which is good for maintaining cash flow. It's not a grant, and so it does. Those taxes do need to be repaid, and the timetable for repayment is that half the delayed taxes need to be submitted by December 31st of 2021, and the remaining half need to be submitted by the same date, December 31st of 2022. And finally, we get to the unemployment benefits expansion. This provision really did a number of things to make more benefits available for more people for a longer period of time. The first thing it did was create the temporary pandemic unemployment assistance program, which means that the eligibility for unemployment compensation benefits extends to individuals who wouldn't normally be eligible for unemployment benefits, including self-employed individuals and independent contractors. In addition to the temporary pandemic unemployment assistance program, the unemployment comp provision provides benefits to employees as well as independent contractors and self-employed individuals who are completely or partially unable to work because, and there are a number of categories. The applicant himself or herself has been diagnosed with coronavirus or is experiencing symptoms. That individual has been ordered to stay home, has been by the government or by a doctor, or that applicant is having to stay home to care for another individual who has coronavirus, or a child who can't attend school. I won't read through the list, but basically it confirms that people who lose their jobs because of the coronavirus or because of the government response to the coronavirus are eligible for unemployment comp benefits. Now, as I said, the Act allows for people, for unemployed individuals to receive benefits for longer. Specifically, it's 13 additional weeks of unemployment compensation benefits in addition to the duration of benefits that are already provided to employees by their state. And secondly, through June 30th of this year, this will provide an additional $600 per week of unemployment comp benefits on top of the benefits that the employees would already receive from their state program. All right, and that does it for the main program. And at this point, we are doing a live Q&A. And to participate in this, please submit questions by clicking on the Q&A area on the right side of your screen. And it's possible, we have about 15 minutes left, I believe, so we should be able to get to everyone's questions, but if we don't, please send us an email, and we would be happy to respond to you after this webinar is over. All right, I'm not receiving any questions yet. Maybe people are still typing in, so I'll go through some commonly asked questions that I've heard from clients, and that I'm sure a lot of other companies might be wondering as well. So number one, exactly how do you calculate the number of employees for purposes of the 500 employee business threshold? Do you include only full-time employees? Do you include part-time employees? What about temp employees? What about employees who are leased to the company by a third party, where the third party is a W-2 employer? And the answer is that you include all of those, provided all of those categories of employees. So full-time employees, part-time employees, temp employees, seasonal employees, laborers who were leased by a third-party company. All of them are included in the calculation of how many employees the company has, as long as they are based in the United States. So you don't count employees in India. All right, next, when calculating the paid leave that's due to employees, should overtime hours also be included? So this goes to the fact that when people are entitled to paid leave, they're entitled to leave for basically all hours worked. So if a person works on average 50 hours a week rather than 40 hours a week, that would really 50 is what the employee has to be paid for. The caveat to that is that there are the caps. Number one, there are the daily caps on the amount of wages that you can pay to them. And number two, there's the cap on the number of hours of paid leave that employees are entitled to. So a full-time employee is entitled to 80 hours or eligible for 80 hours of paid leave under the Paid Leave Act. And so if that employee works 50 hours a week on average, then for the first week, that employee would get paid for 50 hours of paid leave. The second week, that employee would only get 30 hours of paid leave. So it has to stay within the 80-hour time frame.
Hey, Colin, I'm seeing a question that's posted by one of our attendees. I don't know if you're seeing them on your screen, but
yeah, I'm missing it, but go ahead.
Nope. I just want to make sure that we're tackling some of the burning questions that some of the people attending are having.
Sure.
This may go toward the last question that you'd asked, but I don't know that you answered it in this way. But the question is, with respect to a non-for-profit with more than 100 employees, which is under a stay-at-home order, will that not-for-profit receive a credit for all wages, even if employees are working remotely? That is, does the restriction of wages paid to non-working employees apply to the not-for-profit? It's not entirely. I'm not entirely clear what that means. I believe that that's asking, if you're calculating the amount of loan forgiveness under wages, do you need to count and calculate the wages for the employees that are in a stay-at-home order?
I have not seen that issue in the nonprofit area, so I would need to look at that further. With respect to employees who telework, who are subject to stay-at-home orders but are working from home, and perhaps I apologize if I'm misunderstanding the question, but I just want to clarify that those employees would not be eligible for paid leave. And so if you're teleworking, then you would still be you would not be subject to or covered by the Paid Sick Leave Act or the FMLA. And Brandon, why don't you take charge of the questions?
Sure. So I've got another one here for you. So concerning the $600 per week provision in the CARES Act for self-employed workers, how do you specifically apply for that through Florida State Reemployment? The application is still just a standard application with no mention. Will they make that determination in their review of the information?
I believe that's still awaiting clarification. I haven't seen anything on that at the moment, and I apologize. This has been an interesting time with new guidance coming in seemingly every single day, and still more questions left unanswered. But I will, if the questioner will send me an email with the question, I can get back to them when that information is available.
Okay, looks like we've got time for at least one or two more. I have another question from an anonymous poster. The question, Colin, is what is the interpretation under the FMLA if an employee is out on FMLA and during the 12 weeks, their business contracts and the position needs to be reduced or eliminated? Do you have to continue to pay through the duration of that period? And what if the position is eliminated upon that employee's return?
Okay, so if that person's, if an employee's position gets eliminated or their business shuts down, then they are not eligible for paid leave during the time that their position is eliminated or the business is shut down. And so that applies whether or no matter when the employee has requested leave. So if an employee takes leave to care for a child whose school has closed, and during that the 12-week period, first 2 weeks, the person's getting paid under the Paid Sick Leave Act, and the remaining 10 weeks, he or she is getting paid under the FMLEA. If while that person's on leave, the company closes down or it does a layoff, reduction in force that includes that person's position, the employer has to pay the employee for the leave time prior to the shutdown or layoff, but they are not required to pay the employee or to continue paying the employee for the paid time off after the shutdown or layoff has taken effect. So that goes back to the DOL's guidance that in a case like that, even if the employee didn't have the situation of the child being home and having to care for that child, the employee still wouldn't be working because of a reason having to do with the company and not the employee. And so that in those situations, there's no requirement for the company to provide paid leave.
Here's another question. If you have multiple subsidiaries, can you count employees per entity?
That's a good question, and I haven't seen a concrete answer on that, but I would say it goes to the extent to which those companies are truly separate entities. That's more of, I think, more of a kind of a piercing the corporate veil issue, where if you can establish that they're two different companies and they have, even though one's a subsidiary or it's a subsidiary parent relationship, if they have different, if management decisions are made by different groups, then you would separate them when counting employees. If it was a situation where it looked more like a single company that had done a shell game, it might be that might be the situation where they say, okay, that's really a company with more than 500 employees, and we're not going to allow them to take part in the small business benefits, or we're not going to hold them responsible for paid sick leave and FMLEA. So it's really a question that requires a look at the individual circumstances of the companies.
I think we have time for one last question. The question is, or it's a statement with a question: I work for a city, so we can't use the tax credit. Can we deduct the full payment from the federal employment taxes?
All right, say that one more time.
The comment was, I work for a city, so we can't use the tax credit. Can we deduct the full payment from the federal employment taxes? Sounds like an accounting or a tax question.
Yeah, that might be outside my my labor and employment wheelhouse. So if you send us an email, we can try to get back to you. But I'm honestly not sure about that one.
Well, along those lines, Jimerson Birr, we are a full-service business law firm, and we are constantly monitoring every day any aspect of this crisis or the regulations and relief that's put out to assist our clients, and we're working overtime to try to bridge the gap between the available information that seems to be changing every day and connecting those to help our clients solve their real-world problems in as real time as we possibly can. And so, just to echo what Colin said, if you have more detailed questions or you have additional concerns about any of your business's issues that are being affected, and would like some additional advisement or guidance regarding the issues that we presented today, feel free to reach out to us. We will make these materials available to the attendees, and we certainly look forward to speaking with you and finding ways that we can help you through this process.
I agree, and thank you all very much for joining us. We hope that this has been educational for all of you, and we look forward to hearing from you in the future on your thoughts about the webinar or any questions, any follow-up questions that you have and that we didn't get a chance to answer here. So thank you again for coming, and have a great day.
Thank you.